Mr. Crouch. Ladies and gentlemen, step across the hallway, please. And please don't discuss it. I know the 12 of you who are still here, don't discuss this case among yourselves or what's been said or done at this point. Remember that you've got to wait till you hear all the closing arguments and my instruction, final instruction, before you do anything. All right, what is the issue again? Let's state it for the record.
Thank you, Your Honor. It's my understanding that the state intends to replay the body cam video of Sergeant Baker as part of their rebuttal close. Your Honor, the defense objects to the replaying of that video as outside the scope. It's improper rebuttal. At no point during our argument to the jury did I at any time contest what happened in that video or raise that as a mitigating factor to be argued for their consideration. In fact, I agreed to the horrific nature of what happened that morning in my argument. If they were allowed to see that again, it would be improper as outside the scope of rebuttal and would be only put on to inflame the jury and therefore would be prejudicial, unduly prejudicial.
Mr. Crouch.
Judge, I will defer to your wisdom because at this point in the case, I certainly don't want to make any mistakes.
Well, let's do this. Let's go ahead and take our lunch recess right now. For the lunch is on its way for the jurors. Would you rather close your argument before lunch?
Yes,
all right, then let's just take about a 10-minute recess.
All right.
Mr. Simmons, you ready? All right, I think we have everyone here, so let me go ahead and address this. The objection that the defense has is to the playing of the body cam footage in the rebuttal portion of the state's closing argument in this case. And first of all, I would observe that this body cam footage has been observed and viewed by this jury in the trial, and that they are entitled to consider all evidence in their determination of the proper punishment, including evidence at the guilt or innocence phase. Second thing I would observe is that the state in its initial opening or closing argument referenced all 5 of the aggravating factors. And those 5 factors, many of them are proven by the demonstration of what was seen on the video. For example, the fact that he was a law enforcement officer and so forth. While the defendant is correct, they did not specifically reference the body cam footage or deny any of that portion of the body cam footage. They did argue that the mitigating factors outweigh the aggravating factors. The state in its closing and rebuttal argument has the right to reference to the evidence that would allow them to argue to the jury that the aggravating factors, in fact, do outweigh the mitigating factors. And that would be the reason that the body cam footage can be played, and I therefore overrule the objection and allow the playing of that video. Now, while we have the jury out, are there any other issues that we need to address in your closing argument, General, that may be problematic, that we would need to send the jury out before we begin? All right, then we are ready for the jury to come back.
Yes, sir.
Ladies and gentlemen, in your absence, I took up a matter, and as I have always instructed you, my rulings on such matters are not for your consideration, and please don't try to speculate or wonder what that was all about. If you will, please just trust that I've tried to do what I think was the correct thing. So, all right, now we are ready for the state to make its closing argument.
Ladies and gentlemen, I can assure you that this is the last time you're going to hear from me. And I'm smiling when I say that because there's not a lot to smile about in this process. And maybe you have seen us laugh and joke during the breaks. Please don't hold that against any of us, because this is an extremely tough case. The weight of this case, well, you know. But I want to talk about the word weight for just a minute, because it's been used several times in the sentencing portion. We've talked about weights, measurements, diagnosis, computers, technology, interpretation of computers and technology. But I want to go back to weight. I told Dr. Agakar that I'm weighty, that I was a fat boy. Some things you can measure. You can put me on a scale and define how much I weigh. But some things...
Mr. Krause, may I ask you, I'm sorry to interrupt you, but since we are making a recording of this for the state's record, I just would ask that you try to speak as loudly as you can. If you're not,
Yes,
I'm not inhibiting you from walking away from the podium, because I know that's just your practice, but I would like for you to speak up as loudly so that the recording for our recorder is picking up.
Some things can never be weighed. Not by science, not by doctors. Happiness, sadness, grief, stress. There is no scientific way to measure or to weigh these items. And you've been given today factors and proof, and you've heard from the defense circumstances they're asking you to consider, to weigh, to measure. And there is no scientific way to weigh any of these issues. It's up to each of you individually. Some things can only be determined, their weight, after it's over. For example, stress, the relief from stress. You may feel a weight while it's ongoing and only know that weight was there after it's over. You have a weight on you, a judgment call to make in this case. And I want to help you define weight, or at least give some parameters to what you should consider. State of Tennessee versus Scott Wiggins. Oh, wait a second. This is not the state of Tennessee versus Scott Wiggins. This is the state of Tennessee versus the defendant, Stephen Wiggins. Well, what you heard a lot of this week sounded like state of Tennessee versus Scott Wiggins. A dead man. Not available for questioning. From all the proof, it sounds like he was a horrible person. It does. But this case that you're here for is not to weigh and measure and convict Scott Wiggins. It's to weigh and measure the defendant and his actions. So forget that slide. Forget that. Let's consider what really happened in this case. You heard how Scott Wiggins liked to go fishing. Well, this man on the screen, he did too. Sergeant Daniel Baker loved to fish. He loved his family. He loved his daughter, loved his wife, loved his law enforcement officers that he worked with. He loved to serve his community. But he will never again go fishing, and he will never again be able to put on a badge. Now that's weight. Can you define it? No, but that's weight. Things that have been taken from you. This case isn't about Scott Wiggins, it's about the defendant and what he's taken. 17 years. 17 years that the defendant was away from the influence of his father before he killed Sergeant Baker. You heard testimony that he was removed. His mama, they left that house in 2001. And he wasn't under the influence or constraints of his father, Scott Wiggins, anymore. 17 years went by before the defendant murdered in cold blood Sergeant Daniel Baker. 17 years. 17 years for him to develop as a human, as a person, as an adult, to have a child, to get a job, to get a GED, to become, as we've heard the testimony from Mr. Schaefer, a successful of making decisions, of plumbing an entire house, of saving money, of driving a car, of interacting in the world on a day-to-day basis without committing murders every day. He was out from the influence of his father for 17 years before he, in cold blood, killed Sergeant Baker. So while he did suffer as a child, 17 years went by. And that's why this case is not about what Scott Wiggins did to Stephen Wiggins. It's about what Stephen Wiggins did, the defendant in this case, today, here, now, with people in this courtroom suffering from it. You heard the defense counsel in both their opening and closing statements say there's no excuse for what the defendant did, and that's right. There is no excuse for what he did. What he did on May 30th, 2018 is not connected to what happened 17 years before. The defendant's own expert witness, Dr. Agakar, literally said to me, agreed with me, that the deficits suffered by the defendant, he conceded this, that the deficits of the defendant did not cause this homicide. Did not cause this homicide. He got off that stand and shook my hand right there. He conceded. We all have deficits, all of us. But they don't define us. They're not who we are. It's the balance of our strengths and weaknesses that define us. And that's what Dr. Schott was explaining. That no one test can define who we are. A battery of tests that occurred after the homicide. Now that's tunnel vision. That's armchair quarterbacking, trying to define the reason something happened after it happened.
And I told him, I said, look, I gotta use this pair of pliers down here. He's like, okay. And he steps back and he's got his hand on his bit. Well, I get the pair of pliers and I'm trying to get the two leaves, because there's two rods in there. You gotta use one to unlock, one to open.
That's the defendant confessing to Agent Neese that he said he had to have pliers to open his car door. And you know beyond all doubt he didn't have to have pliers to open that car door. But even 2 days after the homicide, he's still trying to convince Agent Neese that you had to have pliers to open that car door. And here's why I bring that up. One, we know it's a lie. We know it's a lie. We've seen the car door open. Two, he can recall stories. You heard multiple of the defense experts say, well, one of the tests he failed is that he can't recall stories. Well, he can and can well. Now, he might not want to recall stories when the defense experts are interviewing him a month before this trial starts, but he could recall stories on this day. He recalled this lie over and over and had no problem with it, trying to convince law enforcement that that car door wouldn't open, to mitigate. You've heard that word a lot. With Agent Neese, he was trying to mitigate what happened and share the blame, push the blame towards Sergeant Baker.
And he walks around and like he's trying to yank my wife out. And I mean, I know she hasn't done nothing wrong.
Really? That's a lie too. He's saying, she tried to yank my wife out, accusing Sergeant Baker of trying to yank his wife. He's not even married to her. Trying to yank his wife out of the car. You know that's a lie. You know that's a lie. You saw on the body camera, that didn't happen. But again, he's trying to convince somebody else that a falsehood occurred. Now, what's he trying to tell these experts? Is he telling them the truth? That's what you have to weigh, and that's why I'm trying to say some things can't scientifically be measured. You got to balance it. When is this guy telling the truth, and when's he telling a lie?
Stephen, if you don't care, show me how you pushed on his chest. Kind of demonstrate to me how you pushed on his chest. When you said you're former fire and rescue.
Yeah, across basement. I had the gun in my hands, so I just let it cross and pushed.
How many times?
Anywhere from 5 to 10. I think it was 8. And to me that because you're supposed to push 8.
But
it wasn't. Like I said, every time I pushed, just moved like.
did you push on his chest before or after the 2 rounds?
Before I backed up, I walked over to him and pushed, and he didn't. Like I said, it wasn't nothing but pouring more blood out of him. And I touched his neck, and it wasn't no heartbeat. And there wasn't no breath at all.
You know that's a lie. You know that's a lie. You can watch the video. He didn't walk over, check his pulse, give compressions, then back up and shoot him. No, he got out, walked up, and shot Sergeant Baker in the head 2.5 to 3 feet away. He never gave chest compressions, never checked his pulse. He is mitigating. He is mitigating his role in the murder of Sergeant Baker and trying to mitigate again today. Now here's where you really have to start weighing and balancing. You just saw 3 lies, proven lies of the defendant. In the interview with the expert, Dr. Carey, he can only draw 1/4 of a clock. But the next expert, Dr. Aguilar, he draws the entire clock. There's no difference in that than saying, I gave him 8 chest compressions and checked his pulse. He's lying. He's mitigating. Lie. Look, it's obvious he's lying to these experts. He draws 1/4 of a clock on one day and the next an entire clock in one of the tests. Now you know why Dr. Schott was saying you can't just look at the results of tests to define an entire person. And the disease doesn't define the man or the woman. It's the whole person test. Why is he doing that? The defendant told Dr. Agakar, and Agakar put it in his report, he was unable to correctly interpret 3 proverbs. That's on one expert. What's the next one? Reasoning and abstract. Reasoning, Dr. Small, Middle Tennessee Mental Health, appears cognitively intact, can explain proverbs. Who is he lying to? Why is he lying? He's mitigating. He's mitigating. He's mitigating his involvement. To Dr. Small, patient reports his brother died 2 days before the homicide. Ladies and gentlemen, his brother took the stand and testified on his behalf. But that day, he tells Dr. Small his brother had died 2 days before, and that's why he was so upset, and that's what led to one of his stressors. That's a lie. His lies have been incorporated into these expert reports. And why is that important? Because it devalues the weight, makes the reports less accurate. I even asked Dr. Agakar, and this is why I was asking him these questions. Is it important for the input to be accurate when he's conducting one of these tests? And the answer was yes, because the output, the results of the test, to some degree depends upon how accurate the information they're getting is. Well, they're all getting different information. And the problem with all of these experts, if you noticed, is it was a circular flow of information. It was never reconciled. There's conflicts all through them. They defined a disease and started explaining it circularly. They didn't look at the whole person. Dr. Karen, she was asked, and maybe she thought it was funny, did you measure him? Because she testified to you all that one arm was shorter than the other. But when asked, no, I didn't measure him. But that was stated in multiple reports that one arm was shorter than the other. But ladies and gentlemen, not one of these experts, not one ever actually performed a measurement. So how do we know that one arm is shorter than the other? These reports are full of inaccuracies, primarily because the defendant was mitigating and lying. But Dr. Cairns is a perfect example. She probably assumed that somebody else had done a measurement. Keep in mind, all these experts are from different states. None of them from Tennessee, but from different states. And they're being emailed or mailed or however, FedExed reports from each other, shared back and forth, but not one of them ever actually measured the defendant. So before you start assigning a lot of weight or value to these expert reports, keep in mind they're full of flaws. Here's another one. I asked Dr. Bigler right out of the gate, what day did the MRI and PET scan actually occur on? And he looked at his report and said, August 5th, 2020. And then I asked him, if you remember, well, are you sure? Because the actual date on the image says June 5th of 2020. And he said, well, I must have made a mistake. It must have been June 5th. But twice in his report, he says August the 5th. And the reason that question was important to me on that day of Dr. Bigler is because in Dr. Newborg's report, it says that the scan was done on October the 9th of 2020. And Newborg says that he got scans and images, and Bigler got scans and images. They all got them from the same place, Vanderbilt Hospital. But you never once heard anything as to who did the scans. Where did they even come from? How do you know it's even this guy's brain? Why are their dates all wrong? Why is there so much inaccurate information in these reports? Why is the defendant lying throughout the mitigation reports? Because he's mitigating. He's mitigating. He wants to increase the value of weight that you assign to his excuses, for killing the defendant. Before entering jail, the defendant has this tattoo. Crush your enemies, show no mercy. That's before he goes to jail. Tattoos can mean a lot of different things to a lot of different people. Maybe it was impulsive to get a tattoo. Maybe it wasn't. But it reflects something. You have to assign some weight to that meaning. Was that his philosophy of life? Show no mercy? Crush your enemies? He showed no mercy on May 30th of 2018. None. None. Not yet. I'm almost finished. The defense quoted in their argument Dr. Agakar several times that it was scientific, concrete evidence. But it's not. None of these experts have scientific, concrete evidence. We all know that an image can only show so much. And there was only one image, presumably, created. They don't have a before and after. And you heard Dr. Schott explain that fluid on the brain is in a lot of people that live perfectly normal lives. We know nothing more. First of all, you have to even consider whether those images are even accurate. Because again, you never heard where they actually came from, or who conducted them, or what state the defendant was in when those PET scans and MRIs were conducted. Was he sleeping? Was he on his medication? How much of his medication? Who had administered his medication? At what time? Every one of those experts said that medications can have an impact on PET scans and MRIs. Methamphetamine can alter the structure of the brain. Dr. Schott, in his testimony, said that the defendant admitted to him that while in the Robertson County Jail, he still had access and used methamphetamines. So when that PET scan occurred and the MRI, had he used methamphetamines in the jail that day? We don't know. The reliability and accuracy of those expert reports is in question. You have to assign some weight to them, but I bring these points to your attention because I think you need to be very careful in how much weight you actually give them, because you know for a fact that some of it's inaccurate. So if some of it's inaccurate, how much of it's inaccurate? The defendant got this tattoo while he was in the Robertson County Jail, while he was awaiting trial in this case. And to me, this really summarizes it. Because as the defense stands and asks you not to give the death penalty, the defendant's in the jail getting a death row tattoo. And I want you to weigh that against his mitigation arguments. While on the face of it, they're trying to mitigate, he's literally in the jail getting a tattoo. I ain't got time for death row, hell-bound. Mitigation and that tattoo do not reconcile with each other. How do you reconcile somebody asking you to mitigate while they're literally getting this tattoo in jail, awaiting this process, this case? Mr. Evans argued to you that you'd seen proof of a letter, in the form of a letter written to me, offering to let him plead to life without parole. They sent me that letter. And you see this tattoo. They don't reconcile. What does this mean? We have been very cautious not to try to overexpose you to the images and horrible circumstances of this case. But in light of the fact that the defendant is asking you to mitigate, I think it's appropriate to show one and final time while we're asking you to find all 5 of those aggravating factors and sentence this man to death.
I'll take that. That'll work. All right, where's your item at? And 500. Tag him out with boy Robert Young 013. Stand ready. Hang on. What's that, your driver's license now? No. Oh, wait a minute. Go ahead. Go ahead. Here's 10-1. Actually, copy. I'm at the corner of Sam Vineyard and Tidwell Switch. You can hands up your legs and get out of the damn car. Get out of the car. Get out of the car. Get out of the car. Unlock the damn door. Unlock the door right now. today.
I'm fine. Come on, I gotta get to your face.
Open the door.
Look, I got to sleep on.
Open the door.
I know, I got to sleep on.
Chris, where are you at?
I'm fine, bro.
Get.
I'm fine.
Open the door.
Open the door. Fuck that door, okay? I'm fine.
You keep your hands on Sam.
What's wrong, bro? What's wrong?
I explain to you, get out of the hole. Get out of the hole.
Look, I'm not going
Keep your hands above the bed so I see him.
It takes a fire fire most of the time to do this.
Where's your fire?
I'm here.
Yeah.
Okay?
Yeah. Yeah, you're fine. You're good.
Calm down.
You're good. Come on. Alright, good. This one go there. Was that door on the passenger side open? Alright. You put your hand up there on the steering wheel. You're fine. Alright. Can you climb out the passenger side? Can you climb out the passenger side? You stay right there. You just put your hands off there. Stay right there. Oh, yeah.
The defense told you Stephen Wiggins never had a chance. No. He had lots of chances. He had lots of chances to make the moral decision. And he had the ability, capability of making the moral decision. The only person in this case who never had a chance. Sergeant B. I'm finished. Thank you.
Ladies and gentlemen, the next stage will be for me to read the final charge of the court to you that contains instructions on how you're to go about reaching your decision. And then you will retire to begin your deliberations. But since we are now at a point where we can go ahead and take lunch, I would like for you to go ahead and have your lunch, and then we'll resume and I'll give you that instruction, but then you'll begin your deliberations. I would again urge you and remind you that you're instructed not to discuss this case or anything that's been said thus far until I give you that final set of instructions. So we'll go ahead and allow you to cross over and have your lunch, and then we'll resume. We will stand at recess until 1:45.
All rise.